Dear students, myself Professor M. Madhusudan, Department of Library and Information Science, University of Delhi. Today's topic is the Information Technology Act 2000. As you know very well, you have studied many acts in your course. The Information Technology Act 2000 has generated several activities and invaded practically all major human activities during the last few decades. Along with the practical activities, it has generated offences as well. It is the law that deals with cybercrime, electronic commerce in India. Dear students, in the many countries, they have passed this Information Act long back, but Indian government enacted the Information Technology Act 2000 by Parliament in the 51st year of India and came into exist on 9th June 2000. Since then, it has been amended in 2006, 2008, 2009 and 2017. This act has 13 chapters comprising 94 sections. Of course, it is 14 sections have been omitted and it has 4 schedules, but 3 and 4 schedules were omitted in 2009. Today, I will present salient features of the 13 chapters of the Information Act 2000 along with its utility, importance in the library too. So, I will start with the features of the Act. All the electronic contracts made through secure electronic channels are legally valid, number 1. Number 2, the legal recognition for digital signatures, and 3, security measures for electronic records and also digital signatures for the authentication of any information or matters requiring legal authentication. Provision for establishing a cyber regulatory appellate tribunal under the Act. Further, this tribunal will handle all appeals made against controller's order or adjudicating officer. This Act also an appeal against the order of the cyber appellate tribunal is possible only in High Court. Digital signatures will use as a asymmetric crypto system and also a hash function. For the provision, the appointment of the controller of certifying authorities, in short form it is called CCA, to license and regulate the working of certifying authorities. The controller act as a repository of all digital signatures. This Act applies to offences or contraventions committed outside India. This Act provides the constitution of a Cyber Regulations Advisory Committee to advise the central government and controller. Dear students, I will brief you the chapters in brief. Chapter 1, Preliminary. As usual, this chapter indicates the extent that is the whole of India, date of commencement and application of the Act. Section 2 of the Act provides definitions of the specific terms used in the Act. The definitions of or interest in the Act are computer, data including computer printouts, magnetic or optical storage media, punched cards, punched tapes, alternatively stored internally in the memory of the computer. Electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. Information includes data, text, images, sound, voice, codes, computer programs, software and databases or microfilm or computer generated microfiche. In this, originator means a person who sends, generates, stores or transmits any electronic message or causes any electronic message to be sent, generated, stored or transmitted to any other person, but does not include an intermediary. Chapter 2, Digital Signature. This chapter deals with the authentication of digital signatures and electronic signatures. The digital signatures authenticate the source of messages like electronic mail or a contract in electronic form. The three important features of digital features are: 1. Authentication. They authenticate the source of messages, since the ownership of a digital certificate, it is bound to a specific user. The signature shows that the user sent it. Number 2, integrity. Sometimes the sender and receiver of a message need assurance that the message was not altered during transmission. A digital certificate provides this feature. Number 3, non-repetition. A sender cannot deny sending a message which has a digital signature. Chapter 3 deals with electronic governance. This chapter dwells on a legal recognition of electronic records. Section 4 as well as digital signatures, Section 5 use of electronic records and digital signatures in the government and its agencies, Section 6. Retention of electronic records, Section 7. Publication of rules, regulations, etc. in electronic gazette, Section 8, and power to make rules by central government in respect of digital signatures. It also informs that sections 6, 7 and 8 will not confer the right to insist that the document should be accepted in electronic form. Chapter 4, Attribution, Acknowledgement and Dispatch of Electronic Records. First of all, the chapter deals with to whom an electronic record should be attributed. As per the Act, generally it should be attributed to the originator of the record. This part deals with acknowledging receipt and time and place of dispatch and receipt of the electronic record. Chapter 5 deals with secure electronic records and secure digital signatures. First of all, it is better to know secure electronic records and secure digital signatures. As per the interpretation of the Act, a secure electronic record is one where any security procedure has been applied to the electronic record at a specific point in time. Such a record shall be deemed a secure electronic record from such a point of time to the time of verification. The interpretation of the secure digital signature as per the Act is, if by any application of a security procedure agreed to by the parties concerned, it can be verified that a digital signature at the time it was affixed in one unique to the subscriber affixing it, 2 capable of identifying such subscribers, 3 created in a manner or using a means under the exclusive control of the subscriber and is linked to the electronic record to which it relates in such a manner that if the electronic records were altered, the digital signature would be invalidated. Such digital signature shall be deemed to be a secure digital signature. This apart, the chapter deals with security procedures. Now, coming to chapter 6, regulation of certifying authorities. The chapter embraces many items relating to the controller, the other officers, licenses, certifying authority and so on. It starts with appointment of the controller and other officers and continues with such sections as the functions of the controller and recognition of foreign certifying authorities. Also, licenses deal with licensee to issue digital signature certificates, application for the license, renewal of license, procedure for grant or rejection of license, suspension of license, a notice of suspension or revocation of license. It also elaborates on the controller's power to delegate power to his juniors, his powers to investigate contraventions, access to computers and data. As per the Act's provisions, the certifying authority follows specific procedures and ensures compliance with the Act. Lastly, it deals with the display of license, surrender of license and disclosure to be made by the certifying authority. Chapter 7 deals with digital signature certificates. This Act provides that the certifying Authority issues the digital signature certificate. It also elaborates on representations upon the issuance of the digital signature certificate. Suspension of a digital signature certificate, revocation of a digital signature certificate and notice of suspension or revocation. Chapter 8 deals with duties of subscribers. As per the Act's provisions, the subscriber will have to generate the key pair, accept the digital signature certificate and retain control of the private key. Now, chapter 9 penalties and adjudication. Computer offences are of varied nature. They may involve a standalone computer, a computer system or a computer network. All these may contain personal information, confidential information and various other types of non-disclosable information or data. Computer offences include among others unauthorized access to a computer, computer system or a computer network, downloading, copying or extracting any data, information and database from any of these, introduction of any computer virus or computer contaminant in any of these, damaging or causing damage to any of these, disrupting or causing disruption to any of these, denial of access to any of these devices, helping any person in accessing these devices, charging the services availed of by a person to the account of another person by tampering or manipulating with any of these devices. Section 43 of the Act deals with the penalties of all these offences. For any of these offences, the offender shall be liable to pay damages by compensation not exceeding 1 crore rupee to the person so affected. The subsequent sections deals with the penalty for failure to furnish information, written, residuary, penalty, power to adjudicate and factors to be considered by the adjudicating officer. Now, we will discuss about the chapter 10, the Cyber Regulations Affiliate Tribunal. An appellate tribunal is an assembly of judges who can hear appeals and review lower court decisions. The Act provides that orders constituting the tribunal will final invalidate its proceedings. Chapter 11 Offences. Several computer offences have already been enumerated in chapter 9 titled Penalties and Adjudication. This chapter is exclusively devoted to offences and deals with tampering with computer source documents, hacking with a computer system, publishing of information in electronic form which is absence. The power of the controller to give directions of the controller to a subscriber to extend facility to decrypt information, declaration of a computer system or computer network as a protected system, penalties for misrepresentation of facts, breach of confidentiality and privacy, publishing digital signature certificate false in certain particulars and publication for a fraudulent purpose. The Act also deals with its application for offences or contraventions committed outside India, confiscation of any computer system, floppies, compact discs, tape drives or any other accessories related to it. According to the Act's provisions, the penalties or confiscation do not interfere with other punishments. The last section deals with the power of a police officer to investigate offences. Chapter 12 Intermediaries not to be liable in certain cases. According to the provisions of the Act, no person providing any service as a network service provider shall be liable under this Act. Rules or regulations made thereunder for any third party information or data made available by him if he proves that the offence or contravention was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence or contravention. Chapter 13 deals with miscellaneous. As usual, the last chapter deals with miscellaneous items. The sections of the chapter deal with the power of a police officer and other officers to enter, conduct a search, protection of action taken in a good faith, offences by companies, removal of difficulties if any difficulty arises in giving effect to the provisions of this Act. The power of the central government to make rules and the constitution of the advisory committee. The Act provides that it will have overriding effect. The controller, deputy controller and assistant controllers will be public servants. The central government will have the power to give directions. The controller will have power to make regulations. State governments will have the power to make rules. Dear students, the Information Act 2000 provides legal recognition for transactions carried out using electronic data, interchange and other means of electronic communication, which involve using alternatives to paper based methods of communication and storage of information to facilitate electronic filing of documents with the government agencies, significant changes in Chapter 10 have been incorporated in this Act in 2019 and 2017. The IT Act 2000 provides legal recognition for transactions carried out using electronic data, interchange and other means of electronic communication, which involve using alternatives to paper based methods of communication and storage of information to facilitate electronic filing of documents with the government agencies. Significant changes in Chapter 10 have been incorporated in this Act in 2009 and 2017. The Information Technology Act 2000 has also been emphasized as computer offences can hit any library, and librarians must be aware of computer offences and penalties. Dear students, you are aware that the Information Technology Act 2000 provides many advantages to libraries. It pays ways to the librarians to deals with electronic documents and electronic digital signatures on routine and other the orders of the routine library services. It also reduced the gap between the library users and librarians by way of taking physical signatures on many documents. This Act specifically helps the library in many ways and means. For example, COVID-19 made all the libraries to change their customs and systems and procedures into digital form. In the circumstances, all the library users and all the library audits went into digital form. So, that is the case, the libraries can, with the help of this Information Technology Act 2000, will facilitate the collection of membership fees, collection of overdue charges, order of books and payment of books in electronic means, and all the certificates including no due certificates to its users with using digital signatures and so on. So, it is the one of the best act as per as library routine works are concerned. This act is beneficial to all the libraries in India. Thank you very much.